breaking news, latest update. Let's just say Oko NDC headquarters or more. Chief Justice Ajiatum say Mahama suspended no say free office. Or Abra still on way consultation. Chief Justice Ajiatum say will be free office now with your office not war. This is a justice temporarily with no office be a second intervention. Yanko here a yanko change some proceedings a course. Attorney General a year or more and copy court to the internet disgrace the NDC headquarters or so mamen to say no wajia to me say will be free office and as you are suspended until definitely wajia to me to know God bless you.
Well, what do you anticipate happening? We are yet to even know what the decision of the President and the Council of State is on this matter. But how do you see all these running concurrently and the fact that this interlocutory injunction hearing is also not concluded and how it will affect the proceedings by the President and the Council of State?
I don't think that the Constitution is having any mistake in this regard. The Constitution has robust system as how a thing of this nature should be dealt with. And so I don't share the opinion of the minority because the Constitution provided under Article 2+1 and that of Article 130 as to how a thing is supposed to be done. And again, they are in court actually to do that. And so even if in a case where the President goes ahead to do the thing and the Supreme Court nullify that thing, it will be so nullified. And so I don't think that there is anything that will be a breach in any manner because yes, the Constitution provided that if you, a party, any person in Ghana, if you read the case of Tufo's Attorney General, it is explicitly stated, any person in Ghana who feel that a threatened act that is considered to contravene or flout any provision of the Constitution can go to Supreme Court to stop the person from that. So I think they are in court to exercise that right. And so as it stands now, the right has not been matured enough, or the Supreme Court is not ready or not in the position to give because of the absence of one of the panelists. So we need to just wait. But again, I don't also think, or I don't share the view that the action that is pending before the Supreme Court should operate as a bar to prevent the President from acting in his administrative capacity as enshrined by the Constitution.
Right. So for you, it's not a thing of these happening as a consequence or happening sequentially. They can still run concurrently. I will come back to you. Let's listen to the minority leader, Alexander Afenyo-Marking, who is calling on the Ghana Bar Association to speak in this whole conversation about the removal of the Chief Justice.
The judiciary should not be seen as part of the partisan political system in our country. All we need is to have an impartial judiciary to dispense justice. What is happening is unacceptable, and it's clear that the NDC government wants to infiltrate the judiciary and make it partisan. But my advice to all judges in the country, stand together. Let not somebody create an impression of one of you and think that by dislodging one of you, you will be the next. The next day, you would also be the next. So judges in the country must stand together. The judiciary must stand as one body and make a full statement to condemn this act. The Ghana Bar Association must also stand for the judiciary. Civil society organizations must stand for the judiciary. All these flimsy, pedestrian excuses looking at what is out there. I mean, you wonder whether these are real, grounds for the removal of a Chief Justice. And, well, this is NDC for you.
So that's the minority leader in Parliament, Alexander Afenyo-Marking. And let me come back to you, Raymond Bidema, on your thoughts. The Ghana Bar Association, speaking on this matter, Is that something you would agree to?
I think I side with the minority leader on the part that he said that the judiciary should be allowed to be independent. As a lawyer, it is important for the judiciary to be independent and to be also seen as being independent. But as to whether the civil society organizations and that of the Ghana Bar Association, whatever they will say, will have anything to compel the Supreme Court or any other person to do a thing, for me that is unattainable, because the Constitution has provided for what or how a thing should be done in this manner, and that is where they are also in court. I don't know. I don't believe that any of these organizations coming to speak will have any impact on the matter that is pending before the Supreme Court. So for us, I believe that at this point we should exercise restraint.
Mr. Badema, I mean, just to chip in there, what the minority's concerns are not about the Supreme Court hearing, but about the petitions to remove the CJ. They think that those are frivolous. They believe that this is an unwarranted attack on the person of the Chief Justice, and that's why they're asking the Ghana Bar Association to speak. But having said that, there is also the concern that the minority in Parliament may be going ahead of itself, in the sense that we know that there were petitions to remove two former Chief Justices of this country, and eventually there was no prima facie determined, and they were thrown out. Even for Chief Justice Torkono, in the previous administration, there was a petition to have her removed, but the President didn't give it much attention. We don't know what is going to happen. We don't know what the President is going to say. Some have suggested that the actions of the minority may either prove that there is a case, or may either prove that indeed the government may be attacking the Chief Justice unnecessarily.
Yeah, and I think I mentioned it some time ago on this same platform, that the provision in the Constitution where any petition that is brought before the President needs to be done or need to establish the prima facie case in consultation with the Council of Elders, I think it's an insulator to prevent frivolous petitions. I don't know why the minority in this regard will not wait to hear what will come out of the consultation with the Council of States, because I think that should be the first step in order, because I don't think this is the very first time that such a petition is being brought against the Chief Justice, Lady Chief Torkono, and on several occasions I think that there was no prima facie case made against her, and for that matter they were brushed off. And so I believe that at this point again we need to exercise restraint patience, as I said earlier, so we see whether or not there could be any prima facie case made against her. But as it stands now, there is no case against this lady, because it's a party who is aggrieved with one or two things about her who has presented his or her petition. So we need to wait and see whether there could be any prima facie case against her. Aside that I don't think it is, for me, again, premature even going to say a whole lot of stuff, because as now it is just a petition being brought by anybody, and any one of us could have brought that if we are aggrieved by any action of the Chief Justice, then it is within our constitutional mandate.
I'm grateful for your time this evening. That's constitutional lawyer Raymond Badema sharing his thoughts with us on the latest developments with regards to petitions to remove the Chief Justice and the Supreme Court hearing on some interlocutory injunction applications to hold that process. We've also been joined on the phone lines by Mr. Inusa Fuseni. He is a former MP and a leading member of the governing National Democratic Congress. I'm grateful for your time this evening. Thank you so much for joining us. We've heard from the minority, and they're making some claims. I know your relationship with the President as at the time he was a candidate, and I suppose you may know if there is any merit to what these the accusations of the minority are. What do you know about this?
First of all, the minority appear to be jumping the gun. And it appears to me that they are litigation happy. Because the clear reading of Article 146 of the Constitution, together with the Supreme Court's decision in Ajuichu and the Attorney General, will leave no one in doubt that when an application or when a petition for the removal of a justice or a justice of the Superior Court of Judicature or the Chief Justice, as the case may be, is submitted to the President, there are certain procedural requirements that the President will have to follow. And those procedural requirements, if it is for the removal of a justice of the Superior Court of Judicature, must be forwarded to the Chief Justice for a determination whether a prima facie case has been made up against the Justice of the Superior Court of Judicature. If it is the Chief Justice, the procedure requires that the President, in consultation with the Council of State, must determine whether the petitions raise a prima facie case. Everything about the petition, whether it is for the removal of a Chief Justice or a Justice of the Superior Court of Judicature, must be held in camera. I don't know why this panicky behavior. Why? Because you need to protect the dignity and sanctity of the office of the Chief Justice or the office of the Superior Court, Justice of the Superior Court of Judicature. You don't have those matters do not come into the public until there is, first of all, prima facie for the establishment of the committee, and then for the committee, if a prima facie is established, for the committee to sit in camera. Because even if a prima facie decision is made, that doesn't mean that the committee will return a verdict of, if you want, for a lack of better word, guilty.
You're right. You're absolutely right. But my question is there any merit in what the minority is claiming?
There's no merit at all. They're just making the matter excessively partisan. There's absolutely no merit. Because everything has to be done in camera. So why is it that when Nana Akufo-Addo received a petition for the removal of the Chief Justice and went through the motions, the majority then, now minority, did not go to the public to raise issues against Nana Akufo-Addo? Why didn't they do that? That's hypocrisy of the highest order. Hypocrisy, they're hypocrites.
Do you also get a sense?
What convinces them that the decision of Nana Akufo-Addo, Nana Akufo-Addo was going to arrive at a decision that was acceptable to them, and John Mama is going to arrive at a decision that's not acceptable to them? What is a litmus test?
Well, they claim they've seen the petition and that the contents are frivolous, and that they also have intelligence that the president is planning to suspend and remove the CJ and replace her with an NDC sympathizer.
You see, no matter the level of intelligence, no matter the leaks that you will find, the minority cannot substitute themselves for the Council of State. They must know, as minority, they are members of Parliament, and the Constitution, which is the supreme law of the land, has designated their role within the governance framework of this country. So, in fact, they must be in their lane. As we speak, the only institution of state that is mandated to consult the Council of State to determine whether or not there is a prima facie case is the president, and not minority.
But are you
suggesting
that if they have concerns about a process, they cannot raise those concerns?
What are the concerns? Everything has to be in camera. The concerns that could be legitimately raised is if the president had acted ultra vires.
So how would you suggest they should have channeled these concerns they've put in the public domain?
First of all, what are the concerns? A figment of their own idiosyncratic understanding of what is going on. Our concerns? Is that what our concerns? The president has not arrogated to himself the power to determine whether or not a prima facie case has been made. In his letter, he told us that he's going to do that in consultation with the Council of State. The Chief Justice rose and said, by her practice, anytime a petition was referred to her to determine whether or not there's a prima facie case, she invited the respondent to answer to the petition. And so she wants to be treated just like she treated other respondents. The President acceded to her request, gave her 10 days to respond to the petition. She's responded. The matters are now within the Council of State and the President of the country. We have not heard from the President. We have not heard the advice of the Council of State. Have they read Article 146(10) of the Constitution? It is the Council of State that will advise the President before the Chief Justice can be suspended. Have they heard from the Council of State?
So do you suggest so should they have written to the Council of State, for example, if they have legitimate concerns? Right.
They're just fucked. They're just back in a hurry and plunging this country into needless debates.
I'm grateful for your time this evening, Mr. Fuseni. We'll continue another time. Thank you so much for joining me on News Tonight. That's Mr. Fuseni, a leading member of the NDC and former MP for Tamale Central, reacting to the concerns by the minority on a certain intelligence they have received regarding the petitions to remove Chief Justice Torkono. That'll be all for Insight. I'll be back with more Tuesday.